thank you for joining us today for our Business Leader Series Online, the official Facebook Live webinar of the Greater Arlington Chamber of Commerce. We are thrilled that you're able to join us for this very interesting event today, where we're going to deep dive into some legal issues that a lot of small businesses are encountering during this pandemic. Before we get started, as always, we want to thank all those on the front lines that are continuing to push our economy forward as we reopen, and thank our first responders, our medical workers, fire, police, delivery, grocery, their postal service. There are so many people who have kept our economy moving during this unprecedented time. So we are incredibly grateful to them, and to our small business owners who have persevered through this, through these circumstances, and we appreciate and are here to support you in any way that we can. So as we transition into our topic today, we are thrilled to welcome Harris Cook Law. So we are talking about employment and contract legal issues during a pandemic. So we're going to introduce Larry Fowler. Larry Fowler Jr. is an attorney with Harris Cook Law, and he handles cases in the areas of general, corporate, and real estate law. His cases typically involve assisting clients in resolving problems related to governmental regulations, contract lease interpretation, zoning and land use disputes, landlord and tenant issues, condemnation, and enforcement of agreements. And a lot of that stuff is very relevant, especially right now. Larry has been officing in Arlington since 1985. Throughout the years, Larry has been an active member of our community. He currently serves as the president of the River Legacy Foundation Board of Directors and as a member of the Board of Directors of the Arlington Convention and Visitors Bureau. Larry is a past chairman of the City of Arlington Planning and Zoning Commission. He was named the City of Arlington's Volunteer of the Year in 2017, and he's also been a very active member of the Greater Arlington Chamber for decades. He even served as our board chair from 2017 to 2018, and we are thankful for his continued service to the Greater Arlington Chamber of Commerce. So we are going to welcome our friends at Harris Cook Law. Thank you so much for joining us today.
All right, we are excited to be here, and thank you for letting us reach out to you and the other members of the business community. I mean, it's especially with what everybody's going through now, it's important for all of us to keep in touch and let everybody know what's going on. It's funny, before the pandemic, I had no clue what a Zoom meeting was, never participated in one, but now we do them multiple times a week. And, you know, I've kind of gotten to where I kind of like them. So with me today are two other of my partners here at Harris Cook, Melinda Barlow and Paul Johnson. Melinda has nearly 30 years of legal experience in North Texas. She spent much of her career representing organizations in matters involving allegations of discrimination, violations of state and federal labor laws, internal investigations, and employment agreements involving non-compete clauses and independent contractors. Melinda is board certified by the Texas Board of Legal Specialization. She also is active in the legal and the Arlington civic community, having previously served in the Arlington City Attorney's Office and currently serving as a board member of the Arlington Bar Association and as an adjunct professor at UTA. And then Mr. Johnson over here on the end, he is a real estate and business attorney with over 30 years of experience in complex business and real estate transactions. He is board certified in both commercial and residential real estate law by the Texas Board of Legal Specialization. Paul studied at SMU where he got his law degree, and then he went off to London and got a degree from the London School of Economics and Political Science, where he earned a Master of Laws. So he's way too smart to be here with us, but we're happy he is. Paul's active also in the community. He currently serves as the chair of the Arlington Tomorrow Foundation Advisory Board, or Advisory Committee, excuse me, and on the Real Estate Law Exam Commission for the Texas Board of Legal Specialization. He served as the chair of the Real Estate Law section of the Tarrant County Bar Association, as a board member of the Downtown Fort Worth, Inc., and served on the Arlington Chambers Technology Council and Real Estate Advisory Committee. And we are going to start today with Melinda talking regarding the employment law issues, because I suspect most of the folks that are out there watching this, they deal with that, you know, from sunrise to sundown. And so I want to make sure that Melinda has the opportunity to share with you her information related to the employment issues.
Thanks, Larry. Good afternoon. So I think we can all agree that a number of employment law related questions have risen as a result of this pandemic and the significant impact on the physical structures of our businesses, the employee functions, the employee wellness, employee family care, and obviously the economic impacts. It would be impossible for me to cover this topic completely in this short time. And I want to emphasize that many of these issues and the answers are still evolving, like everything else. I understand that previous webinars have focused on the PPP, so I'm not going to talk about that today. What I want to discuss broadly are a few areas that I hope will alert you to recognize some potential issues that could be potential violations of federal law or perceived discrimination. Hopefully, this will allow you to be in front of the potential issues as you work your way through the challenges of resuming your operations, continuing your business in this pandemic environment. The goal is that I illuminate some of these areas so that you may not have thought about, and you're able to handle them appropriately at the front end, avoiding potential claims, or at least setting you and your business up in case you do get a future claim to be able to defend that. So as I indicated, it's really no secret that many of these businesses, and yours as well, are facing huge economic challenges that include changes to your operations that may be temporary and permanent. With that comes layoffs or reductions in your force and or reorganization of some work units, including reassignment of employees to different, sometimes lesser paying or lesser prestige positions. Even though Texas is an at-will employment state, when you terminate an employee or change their job, if that change is perceived to be adverse, if it's less money, less responsibility, diminished career opportunity, or even perceived a lesser favored shift, that employee may have a claim that the termination or a reassignment of the position was not for a legitimate business reason, but rather had a discriminatory intent. Thus, when you're considering layoffs, reductions in forces, and reorganizations and reassignments, you must consider whether you're impacting individuals that are in a protected class, such as race, age, gender, ethnicity, religion, disability, or potentially just recently exercised some FMLA leave. This needs to be considered if you're considering just one employee or if you're considering changes to multiple employees. With multiple employees, you must consider not only whether it impacts that individual employee, but whether it may impact a protected class disproportionately, and we call that disparate impact. For example, if you have 10 warehouse workers and all of these warehouse workers have the same job description and the same job responsibilities, and because of the economic climate, you need to reduce to 6 warehouse workers. If you made the decision to eliminate the 4 oldest warehouse workers because maybe they can retire and or very close to retirement, and you just think that that's the nice, kindest way to go about it, you would be disproportionately impacting a group of people over the age of 40. And that would potentially be an age discrimination claim.
You mean when we're over 40, we're old?
Unfortunately, we are. So I've been old for a while now.
Wow.
So I'm going to talk about some tips here on how you go about doing this. So first of all, if you have multiple positions that are going to be impacted, you need to have a list of these affected positions, probably a spreadsheet. And then you need to examine this sheet to see if any protected group, gender, again, race, age, is disproportionately impacted. If any protected group is disproportionately impacted, at that point you may want to consider consulting with an attorney so that the communication surrounding how you brainstorm to address this issue are protected communications. But at any rate, you're going to have to address that issue. And I'll talk about what type of things you'll need to address that issue. You also need to keep statistical data of all the impacted employees for any layoffs or reorganizations that you do. The biggest thing that you will need to do is articulate a business justification for any and all of these changes. You need to build a file to support what we call your legitimate, non-discriminatory reason. So you are looking at objective things that are unrelated to the person's age or their gender or whether you perceive them to have a disability. You look at your policy. If you have a policy, and this seems like a no-brainer, but you would be surprised how many times I've seen this happen. Sometimes people don't realize that they've actually have this in their personnel policy, and then they act contrary to that. That looks really bad if a person does then file a claim. That's really hard. That's a hard one to get over. So if you have a policy, you need to follow it. If the policy states that the person with the lowest seniority in his or her position will be laid off first, then that's what you need to do. You may not like that policy. It may have an impact that you didn't intend, but I don't recommend that now is the time to change that policy. That may be something you need to look at ongoing or down the road. If you have no policy, then you need to create some objective standards that are going to be applied, and then you apply them to each employee group, to each employee consistently across the board. So if positions are eliminated, follow the functions to see who gets those positions. The reason you want to do that is sometimes positions will be eliminated and basically you have just assigned all those functions to another employee that you didn't eliminate, and you never considered that employee as part of the group of impacted employees. So they would need to be considered when you're looking at whether there's a disparate impact. So it's important to know where those functions go. You may not do those functions anymore, or they may be reassigned and you may have a new job description, but it's important to know that. If it's someone outside the protected class, then it may appear to be a pretextual reduction in force. So that's why you want to know and be aware of that. If you're reorging or reclassifying, the new job description should show a significant change, not just a new title when you're displacing an employee. So you can't just change somebody's title and give them all the same job functions that they had before and say, okay, well, now your title is assistant instead of primary, but oh, by the way, you're doing the exact same job and you're making less. You can do that, but again, you need to have the articulated business justifications for that and be aware that you are doing that. So moving on to another topic, generally employers recognize that it's a minefield to instigate conversations with employees about their medical conditions. Yet in this pandemic, medical information can be vital to employers who want to keep the employees as well as their customers and clients safe. So as an employer, what kind of conversations can we have with an employee about their health issues? Well, first we look at the Americans with Disability Act. Generally, the American Disability Act prohibits employee disability-related inquiries or medical examinations unless they are job-related and consistent with business necessity. A disability-related inquiry or medical examination of employee can only be done when the employer has a reasonable belief based on objective evidence that either A, an employer's ability to perform the essential job functions will be impaired by a medical condition, or B, what's going to be important to us, an employee will pose a direct threat due to a medical condition. So fortunately for us, direct threat is an important ADA concept during an influenza pandemic, and the EEOC has already spoke on this. Based on the CDC and the public health authorities, as of March of this year, COVID-19 meets the direct threat standard, meaning that inquiries about COVID-19 will not be considered discriminatory action when done, again, in an objective and consistent manner. And part of your business operations, it's needed. If it's not needed, if you have somebody working at home, then obviously you don't need to know what their COVID-19 status is. So how long is COVID-19 a direct threat? As we go forward, employers should rely on the latest CDC and state or local public health assessments. While the EEOC recognizes that public health recommendations change during crises and they differ between the states, employers are expected to make their best efforts to obtain public health advice that is contemporaneous in time and appropriate for their location to make their reasonable assessments of conditions in their workplace based on this information. So when an employee returns from a COVID-19 absence, can the employer require a doctor's release or fitness for duty? Again, you may not know this, but in I think it was 2009 when the H1N1 influenza was going around, the EOC prepared a pandemic plan, and what they did is they just updated it. So it's rare that we get this kind of timely guidance. The only reason we do have it is because they already did it. And the EOC has spoken to this issue, and they state that an employer may require employees who were absent from work during a pandemic to provide a doctor's note certifying their fitness to return to work. Now, the EOC, as well as the Texas Workforce Commission Civil Rights Division, has also talked about that employers need to be aware that during these times, one, it may be difficult to get this medical documentation. It may be difficult to get testing to prove a negative test. It may be a financial issue for an employee to be able to pay for a doctor's note. So they're asking you to use your common sense and be flexible to determine what options you may have to reach your goal, which is it reasonably safe based on what we know from the CDC, the county, the state health officials, and this person's medical issue. So if they've been quarantining for 14 days, most of us can say, you know, whether we have the doctor's note or not, they're probably good to go. Depending on, did they actually exhibit symptoms, or were they, you know, just being quarantined because they were exposed to someone else. So there's going to be some wiggle room on that. And I think the wiggle room is going to be towards the employee that may be having difficulty if you get too stuck in what type of documentation you're going to require. If they can require other documentation that would make you believe that it's reasonably safe, then you probably want to consider that. So under current conditions, requests for medical documentation should be done consistently and fairly for all similarly situated employees when you were talking about returning from a COVID-19 absence. So moving on, let's talk a little bit about workplace safety. So you have employees returning. You also have employees that are already there. As an employer, are you allowed to send an employee home if they are showing signs of illness, such as coughing, sneezing, or report that they have aches or chills? Yes, is the short and definitive answer. In keeping with the employer's general duties under OSHA to maintain a safe and healthy workplace for employees who appear to be sick may be asked to go home. Obviously do so as politely and discreetly as possible. Shouldn't be making an announcement to the entire office. Again, employers should be consistent and treat all employees who exhibit risky symptoms the same. And that means if you're the boss, same goes for you. So can an employer lawfully prohibit an employee from returning to work until 14 days has passed since the employee was exposed to the virus, provided that the employee remains symptom-free? So generally in Texas and in federal law, there's nothing that would prohibit a company from telling employees to stay home if they have had a higher than normal degree of exposure to individuals actually infected with the disease. The key is to be consistent and to not base any self-isolation orders on factors such as race or national origin. There's already been scattered reports of ethnic discrimination, particularly against people who look like they may come from Asia. The EEOC is already warning employers that singling out employees based on ethnic or national origin concerns could trigger a discrimination charge. As I talked about, the EEOC has their pandemic preparedness documents, and it's all available on their website. And they've noted that an individual with a disability who poses a direct threat despite a reasonable accommodation is not protected by the non-discrimination provisions of the ADA. So, you know, you don't have to worry about that as far as how you handle the COVID-19 sickness. So at this point, anyone with a known exposure or a positive test is considered a direct threat under the ADA. So employers can rely upon that to make them stay home from work for 14 days or whatever is reasonably necessary. And they should, on an ongoing basis, look to the CDC and state and local public health assessments to determine what's appropriate in that regard. Should an employer tell employees if someone they work with is infected? Again, we're getting into this taboo area of discussing an employee's health condition. However, even though HIPAA prohibits employers from disclosing medical information about employees, employers should not use that to stop from notifying staff that someone in the workplace may have put them at risk. You can do this without naming names. Again, in some small environments, probably inevitably people are going to figure out who it is, but that is not a violation of HIPAA. There's the potential that if an employer fails to disclose this information or withholds this information, that could be a violation of OSHA rules. Also, failure to do so could place the employer at risk for workers' comp claims and or being sued when the employer is a non-subscriber if an employee contracts the coronavirus at work. So really, to avoid running afoul to Title VII and other discrimination laws or the ADA or Age Discrimination Act and some of the other federal laws, employers should be careful that they apply their policies consistently and based on reasonable objective facts as they exist at the time the employment decisions are made. And because these situations may be fluid, it's very important to document those reasons at the time the employment decisions are made. In addition, employers should take immediate action to prevent any types of statements or jokes targeted at persons in a protected class. That would be, again, we've heard some discrimination claims popping up against people of Chinese or Italian descent. This would also be the same for somebody that may have had COVID and returned from work. All of these things need to be careful about how these people are treated. But if you remain consistent and use what I like to call is common sense, sometimes not so common, you're probably going to be okay. But if you have an inkling, if your spidey senses tell you, I don't know, am I getting into a gray area? Am I doing this right? Consulting with a lawyer or an HR professional is always your best bet. Never hesitate to reach out. The time you spend reaching out and the expense that you might have with that will save you so much in the long run, as far as potential claims and also just your own mental sanity.
And we know that mental sanity is important.
Yes, we do.
All right. All right. Next, we're going to get Paul to talk to us about some of the contractual issues that are arising as a result of a pandemic. And I guess I would say to all of you out there, I bet none of you ever thought that you would have to look at your contracts because of a pandemic. And so anyway, I'll turn it over to Paul.
Thank you, Larry, and thank you, Melinda. That's fascinating.
Yeah.
I think we don't really know where all this is going in the workplace and the liability. Thinking of these things like a transactional real estate lawyer, you start thinking about the premises liability and the steps that a premises owner may be representing that they take, but that they end up not taking, and whether any liability stems from that. And kind of the principle that Melinda talked about of, if you say it in your employment handbook, well, by golly, you better do it, probably applies to them too. You better not act like you're taking care of your invitees and then not do it. That actually has nothing to do with my prepared topic today, so I'll try to get to that. Probably going to abbreviate it quite a bit because we want to be respectful of everybody's time. As Larry said, I'm Paul Johnson, and like everyone up here, we're with Harris Cook Law. And my practice is in real estate and business kind of transactions, sort of a general counsel for a lot of companies that don't have a general counsel, and a real estate development lawyer. I'm going to try to boil this topic down into the issues that we're seeing into three main areas. The first is we're seeing quite a few non-performances of contracts is probably a pretty good way to say it. And then we're seeing some issues with landlords and tenants. And while we're not yet seeing these, I'm anticipating we're going to see some lender-borrower issues. So I'm going to try to touch a little bit on all three of those. First, let's talk about a typical contract and what the effect of maybe non-performance is. And let's set up a fact scenario that I'll try to manipulate several times to kind of illustrate what we're talking about. Let's say Larry, in a moment of no wisdom, hires me to sing at an event that Larry's putting on. Larry doesn't realize that I can't sing, but he hires me and he agrees to pay me to come and sing at his event. And I agree to do it in another moment of not very much wisdom. And so Larry has made a promise to pay me. And so I've made a promise to do it. And we have formed a contract. It's called an executory contract. And let's say when the event comes up, I don't show up. I wake up that morning and I realize I cannot sing. And so I don't show up. And so Larry now has a claim against me for a breach of contract because I didn't show up. Conversely, if I wake up that morning and say, by golly, I am a good singer, I show up. Larry, however, woke up that morning and realized that I cannot sing. And Larry says, you can't sing, Paul. I'm not going to let you perform tonight, and I'm not going to pay you, even though you're here. Well, now Larry has breached the contract that we have formed. And so there is liability. Whatever the damages are that flows from the non-breaching party to the breaching party, they must pay. That's basic contract law 101. And I should pause here to say it really doesn't matter much whether you put that contract in writing or whether you form a contract orally. That old saying in Texas of my handshake is my bond, my word is as good as my bond is exactly right. Your word is as good as your bond. And if you make an executory contract orally to do something and the other person then makes his promise in return to do something, they are enforceable. The obvious problem, of course, with not having it in writing is that when you come to prove up that contract, everybody remembers it just a little bit differently and remembers it just a little bit more in their favor than the others. So that's why folks like us like to put these contracts in writing. And so now let's change this up a little bit. Let's say that after forming this contract, and let's assume from here on in that Larry and I have put our agreement in writing. And so we have this written contract. Let's say that after doing that, I wake up the very next day. Well, no, let's say I wake up a week or two later and I realize I cannot sing. And I call Larry up and I say, Larry, I'm not coming. And Larry says, well, I've sold a lot of tickets. A lot of people are coming because they want to enjoy the spectacle of you trying to sing, Paul. And so Larry now has to refund all these tickets because no one will enjoy watching Paul try to sing or listening to Paul try to sing. And so really, that's not much different than what we just talked about, except that I breached that contract by repudiating it early. And so not much has happened so far. It's exactly the result that you would expect there to be, that if I don't do what I say I'm going to do, there's consequences to that. And that consequence in a contract is you must pay damages. So let's change it one more time though. Let's say I live in Galveston. I never realize I can't sing, and Larry never realizes I can't sing. He schedules his event. I wake up on the day of the event and a hurricane is raging outside of my office. And so I get up and I want to go, but I can't because the hurricane has shut down all of Galveston and it is impossible to get out. Let's say it's a Category 4 hurricane, a real bad one. And so I don't show up. Larry has the event. I'm not there for everyone to listen to me sing. Everyone gets mad because they wanted to hear the spectacle and they ask Larry for all their money back. Larry calls me up and he says, Paul, you agreed to show up and sing at my event. And I said, well, Larry, I couldn't get there. It was a hurricane and it was all shut down. It was beyond my control. Larry, it was an act of God. I couldn't get there. And so Larry says, well, I don't care. You didn't show up. It was a breach. And so I say, okay, well, I look at my contract. Unfortunately, I read it for the very first time, like most people who sign contracts when something comes up. And I find this provision that says force majeure. And I say, this might help me. Force majeure is a French term that just means a superior force. And a typical force majeure will say something like, if there is a flood, a fire, a war, a riot, or an act of God, and many of them will go on for a very long time, laying out the various things that could be events that are superior forces, or stated another way, are events that are beyond your control, and they'll lay them all out. And then typically what it will say is it will say something like, if a force majeure event or a superior force occurs that prevents you from performing your contract, then you are excused from that performance. And when you're excused from the performance, you're not liable. So returning back to our scenario, Larry says, you breached, you weren't here. And I say to Larry, well, fortunately, I have a force majeure provision in my contract that says if I don't perform, I'm excused from performance. So Larry, sorry for your luck, but I don't have to pay you any money. Good luck with dealing with your ticket holders. So let's move it one more iteration here. Let's say in this contract that Larry and I signed, I was smart enough as a performer to put in there the notion of a deposit. And my contract says, Larry, not only will I come perform, but I want you to assure me before I fill up my calendar that you're going to pay me. So you give me a deposit. And I go on to say that deposit is non-refundable. And then I go on to say, not only it's non-refundable if you cancel it, but it's also non-refundable if the event doesn't occur for any reason except my breach. And that is what a lawyer would call a well-drafted deposit forfeiture provision. Unfortunately, none of them are quite that well drafted. Well, remember we talked at the beginning about how to form a contract. You form a contract by stating your agreement, or an executory contract, that is one that's to be performed, by stating your agreement and the other person states their agreement. You exchange those two things of consideration, as lawyers like to call them, and you bind yourself. And then when the court comes to examine whether you're right or the other person is right in the event of a claim under it, a dispute, the court will look at the contract. The court will not typically go outside of that contract to ask you, well, what else was going on? And so the general rule is that you look at that contract and you say, it says this happens. We are going to honor the ability of parties to enter into a contract, and we're going to fulfill their intent. And the way we know their intent is what they wrote down. And so a court usually will look at that contract and say that it says X, so I'm going to enforce X. And so if I've drafted my deposit provision, my forfeiture of deposit provision well enough, it most likely will get enforced by the court. So if Larry puts up the deposit, and the easy example is Larry then cancels the event, well, I get to keep that deposit. I may have more damages because, after all, I was planning on making a lot more money under my contract than just the mere deposit. But if I drafted it right, then I get to keep that deposit. So let's take it one further step, and really let's bring it down to what has happened over the last couple of months. These are all these scenarios are taken from several matters that we've been looking at here in the last few weeks. And let's say instead of it being Larry, let's say it's a church, and let's say it's a big church that's planning an Easter service, and so they reach out to a performer and they say, we want to book you for performance at our Easter service to come worship with us and lead our worship. And the singer then has them sign up, has a contract, and the contract has a deposit provision in it. And let's say, although I have yet to see this case, let's say that deposit agreement or that deposit provision was well drafted. And it said, here's exactly what happens in these events. And it could say even if a force majeure event, that superior force occurs, that the deposit goes to me, because after all, as the singer, I'm booking up my calendar and I can't go cover some other place. And so if it says all that, that singer's probably feeling pretty good about it. And so in this example, let's say that it was an Easter service. The church calls them up and says, hey, have you been watching the news? One, we don't think it's safe. And two, we don't think that the county order and the governor's order are allowing us to do this. Let's put them in Harris County down in Houston, because that was a pretty strong order down there. And in Harris County, they, at least ostensibly on the face of it, I believe, were prohibited from having those kind of face-to-face services. Now, the governor's order kind of said it differently, and there's been lots of discussion about whose order trumps, and it's probably the governor's order. But they cancel it, and then the performer, in this case me, says, okay, I understand, but I'm keeping the deposit. And I'm not going to sue you for any other damages. I'm just going to keep the deposit. The church then says, well, wait a minute, this was all outside our control. And they look at there and they read it and say, well, indeed, it does say that deposit is forfeited, but ethically, we just think you need to pay it back. Is there anything we can do? Well, there may be in this situation. Remember, we talked about earlier the fact that a court will respect what the parties say to the contract. Parties to the contract say in that contract. That's not, there are exceptions to that rule, and it's typically when something outside of the contract requires that the court look into it. And you think of things like if someone is induced into entering into a contract by fraud or misrepresentation or some other sort of unequal bargaining position that requires the court to look outside the contract. In this case, though, there's an argument at least that contract is unenforceable under the law, because the church in Harris County's position would say we were prohibited by local local order, the county order, from entering in, from performing that contract. Thus, the contract became an agreement to perform an act that's illegal. Now, we don't know exactly if that's if that works, because certainly nothing's worked its way through the court system. But as you look at these contracts and as you look at these disputes, the fact that COVID-19 came in and the fact that a quarantine came in gives you outside reasons for why maybe you don't have to be bound completely by that contract. As you can imagine, it's a very fact-specific inquiry. Anything in this thing that changes a bit could change the result of any of these things. The deposit agreements themselves are written in many, many different ways. And quite often what you see is the mere word deposit. And so you're sitting trying to decipher what the parties meant by deposit. So in summary, as you have those contract disputes come up, how should you address them? Well, read your contract. Sit down, make sure you understand it and apply the facts to that contract. Then, I can't urge this enough, quite often the amount in dispute becomes becomes not worth pursuing when you start looking at the costs and expenses of pursuing that. And so I'd strongly encourage you to pick up the phone and call the other person. In these disputes that arise truly because of COVID-19, there is no bad actor here. This is something that just happened, and reach out to them and reach a resolution of it. And don't get yourself caught into that situation where you are pouring good money after bad. So I wish I had a nice little blueprint for how to resolve those deposit disputes, but there really is not one, and it's a very factually specific situation. Let's move on now in this limited time to the landlord-tenant situation. We are seeing more and more tenants that just flatly can't pay their rent. And so many landlords are willing to abate the rent. And by abatement, I mean delaying the paying of the rent. I don't mean rent forgiveness. We're not seeing many landlords being willing to forgive rent, but many landlords are willing to abate that rent. As a tenant, if you have those problems, again, I want to urge you, get out in front of it, talk with your landlord. Be prepared to provide financials. Be prepared to give them the recovery plan of why it's a good idea for you to receive abatement. And then one more tip for the landlord-tenant situation: consider, if you did take it, your PPP loan. Remember, the PPP forgiveness comes in with a combination of the following 8 weeks of rental payments and payroll and I think some other things. But don't shoot yourself in the foot by having your rent be abated for that 8-week period during which you really need to have rental expenses. So raise that with the landlord. And I'll say as an aside, one of our clients actually, as a landlord, almost partnered with that tenant and required as part of the abatement evidence of the PPP application, but then they worked together to make sure that any abatement relief occurred after their 8-week period. So communication is key there. And again, if you're a tenant, you want to project the image that you are going to recover, and here's why. And being out front of the PPP loans and raising those kind of issues is very convincing. And then finally, I want to talk about what I think we all expect to be coming up, and that is lender-borrower issues. And one thing that as a borrower you really ought to be doing right now is reading your loan covenants. Those loan covenants most likely prohibit taking out additional borrowings. Now, I'm not sure that many of the PPP borrowers really even looked at their loan agreements, but they most likely said you may not go out and take additional loans. And so what is the result of that? Well, it may well be a technical default under that loan. And again, I urge you to get out in front of those kind of issues. Many of us, Many of the borrowers on PPP loans did it with the same bank that would be their principal indebtedness, but not all of the borrowers did that. And so it's essential to communicate with that lender, to get their consent as you do it, and make sure that you don't have a technical default under there. And then the final point that I would make on lender borrower issues is if you are one of those borrowers who has a non-recourse loan. Non-recourse loans, those of you who are under one, most of the time have carve-outs. They're often called bad boy carve-outs. And those carve-outs have the effect of saying, if you violate any of these provisions, your non-recourse loan becomes recourse. That's a very bad day if you're that non-recourse borrower or guarantor. So as you navigate all these points of relief, make sure that you stay aware of what those provisions are. They're in many ways very draconian, because even a small default under those non-recourse carve-out provisions can result in full liability for that debt that you thought you would never have to have personal liability for. So those are my tips. And Larry, I'll flip this back over to you.
Thank you. I guess building on what Paul was talking about as far as landlord-tenant issues, if you either currently, are contemplating forcible detainer proceeding, or if it's currently, on file, I assume you have figured out that you are in Never Never Land, because right now in our judicial system in Texas, there's a prohibition against jury proceedings until August 1st. And then there are no in-person hearings of any type for forcible detainers, anything that requires a hearing in front of a judge right now. There are no in-person hearings. The Zoom hearings, like we're doing here, those are allowed, and I'll talk about it in a second, but numerous of the courts are doing that. However, I talked to Judge Sanders' office and Judge Cronut's office, the two JPs that cover Arlington, and at present, neither of them are conducting any type of hearings. Now, having said that, the Texas Supreme Court has said, I guess it was yesterday or the day before, that they are about to begin allowing in-person hearings, but it's up to the local administrative judge to come up with a set of protocols and get them approved. And these protocols are going to be things like glass and social distancing, things like that. And so you're going to see in the next week or two, I suspect, that the courts will be open for business in a limited way where they will have in-person hearings. Now, there are, like I say, Zoom hearings going on right now, and both of the probate courts are conducting non-contested hearings, will prove ups, that type of thing, and those are working pretty well. But with regard to, for example, circling back to forcible detainers, for a while, the state absolutely prohibited residential forcible detainer proceedings. That has now been lifted. However, there is still a federal moratorium on residential forcible detainers and it was under the CARES Act. And what it says is that the prohibition, which means you cannot file until July 25th, an action for a forcible detainer proceeding if your property is a property that is participating in any of the federal housing programs, such as public housing, Section 8, housing choice vouchers. So any of those, which is a significant number of the multifamilies, if you participate in any of those programs, you cannot commence a forcible detainer proceeding based on non-payment of rent. That prohibition also applies to any property where the mortgage on the property is a government-backed mortgage, such as HUD or Fannie Mae or Freddie Mac. And so if you got a multifamily project that the deed of trust lien on it is government insured, again, you're under that prohibition. One thing that I wasn't aware of, it's not just multifamily. Let's say you've got a single family dwelling out there that you have a tenant in. If the mortgage on that single family dwelling is federally insured, you've got the same issue, that you cannot commence, any forcible detainer that's for rent. Now, the CARES Act does not prohibit forcible detainers for other reasons. Typically the lease agreements these days will have a provision in them, like for criminal activity, things like that. That's a default under the lease. Those you can go ahead and file your forcible detainer proceeding if you need to. I alluded to probate. One thing that's going on as a result of COVID is the governor has suspended certain statutes regarding appearing before a notary. At the current time, if you have a self-proved will, a power of attorney, a medical power of attorney, a directive to a physician, or an oath of an administrator or guardian, you can have those notarized by Zoom. In other words, you don't actually have to physically appear in front of the notary in order to get that done. And then you can also, as I said a minute ago, the courts are they are conducting, for example, a will prove up, those type of things. If they're not contested, they are doing those pursuant to Zoom. And I checked with, both of the probate courts this morning, and yeah, they are having non-contested hearings. But again, there should be some type of in-person hearings that we're probably going to see sometime in the next couple of weeks. But if, especially right now, if you've got folks that you need, medical power of attorneys or regular power of attorneys, and you're concerned about going and getting it notarized, there's numerous notaries out there now that are set up to do it electronically over, the web-based applications. And then you can actually then get in go and prove that will up at the probate court again over a Zoom hearing. So, all right, looks like we're about out of time, but did we have any questions that you wanted that have come in the interim that we need to look at?
We do have two quick questions as well as our final question that we like to ask. So our first question is from Melinda, and it's, what if an employee does not want to return to work or refuses to return to work?
Okay, well, first of all, generally speaking, employees who are just afraid of coming back to work out of concern that they might contract the coronavirus are not entitled to leave under the Family Medical Leave Act or to any sort of accommodation like working from home under the ADA. Additionally, as y'all may already know, in Texas, those employees may be able to remain on unemployment or get unemployment if they can show the Texas Workforce Commission that they're at high risk, 65 years or older, they have a high risk member in their household, they were diagnosed with COVID, they have a family member with COVID, quarantined, and the big one, childcare issues. So this is an ongoing thing where they might be able to continue unemployment. However, that has not required employers to hold that job open. So that's going to be an option that the employee has, but the employer does not have to indefinitely hold the job open if the employee takes that option. Employers need to make sure that they allow employees, if they have leave of absence policies or personal time off benefits, that the employee has the option to use those if they're uncomfortable returning to work. Another option for the employee, if they do not want to return to work, they can refuse if they believe that there is a danger, they've asked the employer to eliminate the danger, the employers failed to do so. So this is all under OSHA. And again, think about meatpacking plants. Those are some instances where obviously there was no ability for social distancing. So if we're bringing, non-essential employees back into a workplace that the employer is not providing what your local health authorities are saying you need to do, then they might be able to say, no, I'm not going to come back under those conditions. And it would be retaliation for the employer to retaliate against them on that. Now, one of the big questions is on the ADA, if the employee comes back and says, I'm not coming back because I'm scared. I'm not coming back because I have a disease or condition wherein my immune system is suppressed, and coming back would put me at risk. And at that point, we are dealing with an ADA issue, and it's no different than any other ADA issue. And what that means is that the employer and the employee need to engage in an interactive process and discuss what reasonable accommodations, if any, can be made for that employee to continue. Sometimes that's going to be possible, and sometimes it's just not. It's going to depend on the position and what that person is required to do. I want to warn you, I know that there are people, prior to this that, and even during this, that were very, very opposed to working from home. They feel like they're out of control when their employee's not right there, down the hall from them. If we're talking about in this ADA situation, an employee who has worked successfully from home during the quarantine, it's going to be really, really hard if they come forward with the medical documentation to support a reasonable accommodation such as working from home, then you're probably going to have to be able to provide that for them. One other thing, there's still some federal protective leave out there from the Families First Coronavirus Response Act. That's some limited leave related to caring for family members that have coronavirus and stuff like that. You want to make sure that none of those are coming into play. But generally, if it's just, I don't want to come back to work because I don't want to be around people and I'm scared, then there's no law that forces you as the employer to allow them indefinite, unless your own policies do, indefinite leave or anything of that nature.
Man, that was a robust answer. Thank you. We appreciate it. Okay, so our next question is for Paul. Paul, you talked a lot about contracts and just the whole rigmarole of how it all works. But at the end of the day, a lot of it came down to having a conversation. So based on your experiences during this pandemic, have you seen banks and landlords being receptive to tenants and borrowers when asking for relief or asking for help?
Well, thank you. I'm a little afraid to answer this question after such a good, thorough answer from Melinda. But think about what's at work here. Lenders want to be paid back for the money that they loaned you, and landlords want to be paid the rent. And so earlier I said, get out in front of these things, start having a communication. If your landlord believes that you are going to be a good tenant for the remainder of the term of your lease, then the landlord wants to work with you because it's expensive, it's time consuming, and it's not much fun to replace a tenant and put a tenant in there that will pay the rent. It's a crapshoot coming into the new tenant, just like it is perhaps a crapshoot as to whether the existing tenant is going to rehabilitate. And the same goes for lenders. They want a borrower that is going to pay them back. And really, ultimately, that's what most landlords and most lenders are looking for. And so to answer the question, yes, landlords and lenders are very receptive to this, but I have to kind of temper that with it is important that the borrower or tenant project that image of saying, these are difficult times, we're in this together, I'm going to emerge from this. And how do you do this? Well, you have a business plan. You have open communications. You don't give the impression that you're playing a shell game and you're hiding things. Because remember, once you're in default of that loan agreement, once you're in default of that lease, the landlord or the lender can take it away from you. They can terminate your lease. They can accelerate loan payments. And so it's very important to, as the party that owes the money, to be convincing about what your plan is.
Wonderful answer. Thank you. And I think it shows that, and there is such integrity in the greater Arlington business community, and we are so thankful for the small business owners, and they have been transparent and upfront. And so just continuing that transparency and that communication is so important.
So, hey, Britton, if there's members of the chamber that, listen to this, have follow-up questions, things like that, our email addresses here at Harris Cook are very complicated. It's Larry at Harris Cook Law, Melinda at Harris Cook Law, and Paul at Harris Cook Law. So feel free to reach out to us through email.
Absolutely. And we truly appreciate your time. We have one quick last question, and feel free to answer it in 20, 30 seconds, if that. But it's the last question we ask all of our guests, and just one of you can answer it or all. But what is your kind of final message to the small business owners of Greater Arlington as they persevere through this pandemic and they continue to reopen?
Melinda, let's punt to Paul.
Well, I don't mind answering that question because I'm very optimistic. I see things improving. I'm concerned, of course, about a reemergence of COVID-19, but I'm seeing business regenerate. I'm seeing things start up. So I think we're going to be okay. I think there's a very great economy all around us. There's a very, very wonderful group of business people all around us. As Britton said, we have folks, blessed by folks in Arlington and really in North Texas that believe in that principle of a rising tide floats all boats, that believes in the principles that you can have a win-win. And I think we're going to be okay. So
yeah, if the relationship between the borrowers and the lenders and the landlords and the tenants, I mean, they were good before, they're going to be good after we get past Corona. And so, I mean, our community, our business community, I'd be shocked if you see anyone trying to take advantage of the situation. I think everybody, is going to, pull together, and we'll get, this too shall pass.
Well, we truly appreciate your time, each of you, Larry, Melinda, Paul. We know an hour of a lawyer's time is something worth money, so we do appreciate that we had all three of you with us today. And thank you to all of our viewers on Facebook, whether you watched live or you were able to watch afterwards. We do appreciate your continued support, and know that the Greater Arlington Chamber of Commerce is here to support all businesses, big and small, here in the Greater Arlington area. And if there's anything we can do for you, to please let us know. We hope that each of you are able to join us next week. We are going to have a great lineup. I can't fully announce exactly who is what day, but we are working with Commissioner Allen to get her in here to talk about the $30 million Tarrant County has for small business grants. That's going to be coming up very quickly. That has been designated to the county, and those are for businesses anywhere in Tarrant County that aren't in Fort Worth city limits, because Fort Worth has their own funding because they are over 500,000 in population. So keep that in mind. And then we are also going to have the Commissioner of Tarrant County College District talking about everything going on at TCC. And then we are going to fill in that last spot. So other than that, we hope each of you have a lovely weekend. Continue to stay kind and stay safe. And remember, together we succeed. Have a great day.
Thanks.